Questions were referred to us for consideration. We'll now read out the questions and the answers. Question number 1. Are the grounds specified in Article 19(2) in relation to which reasonable restrictions on the right to free speech can be imposed by law exhaustive, or can restrictions on the right to free speech be imposed on grounds not found in Article 19(2) by invoking other fundamental rights? Our answer is the grounds lined up in Article 19(2) for restricting the right to free speech are exhaustive. Under the guise of invoking other fundamental rights, or under the guise of two fundamental rights staking a competing claim against each other, additional restrictions not found in Article 19(2) cannot be imposed on the exercise of the right conferred by Article 19(1)(a). Question number 2. Can a fundamental right under Article 19 or 21 of the Constitution of India be claimed other than against the state or its instrumentalities? Our answer is a fundamental right under Article 19(21) can be enforced even against persons other than the state or its instrumentalities. Question number 3. Whether the state is under a duty to affirmatively protect the rights of citizen under Article 21 of the Constitution, even against a threat to the liberty of a citizen by the acts or omissions of another citizen or private agency. Our answer is the state is under a duty to affirmatively protect the rights of a person under Article 21 whenever there is a threat to personal liberty, even by a non-state actor. Question number 4. Can a statement made by a minister traceable to any affairs of state or for protecting the government be attributed vicariously to the government itself, especially in view of the principle of collective responsibility? Our answer is a statement made by a minister, even if traceable to any affairs of the state or for protecting the government, cannot be attributed vicariously to the government by invoking the principle of collective responsibility. Question number 5. Whether a statement by a minister inconsistent with the rights of a citizen under Part 3 of the Constitution constitutes a violation of such constitutional rights and is actionable as constitutional tort. Our answer is a mere statement made by a minister inconsistent with the rights of a citizen under Part 3 of the Constitution may not constitute a violation of the constitutional rights and become actionable as constitutional tort. But if, as a consequence of such a statement, any act of omission or commission is done by the officers resulting in harm or loss to a person or citizen, then the same may be actionable as a constitutional tort. That's how we have answered this question. Now that we have answered the questions, the writ petition and the special leave petition are directed to be listed before the appropriate bench after getting orders from the Honorable Chief Justice of India.
I have had the benefit of reading the erudite judgment proposed by His Lordship P. Ramasubramaniam J. While I agree with the reasoning and conclusions arrived at by His Lordship on certain questions referred to this bench, I wish to lend a different perspective to some of the issues by way of my separate opinion. The concern of the petitioners in these such as women who may be victims of crime. Such indiscreet speech is a cause of concern in recent times, as it is thought to be hurtful and insulting. The questions raised in these matters are with regard to remedies available in law, so as to counter such kind of hurtful or disparaging speech made, particularly by the public functionaries. I've gone to the prayers sort. Ahead, I've put a table where the questions have been referred, His Lordship's views, that is now the majority's views, and my views. Question number 1, are the grounds specified in Article 19(2) in relation to which reasonable restrictions of the right to free speech can be imposed in law exhaustive, or can restrictions on the right to free speech be imposed on grounds not found in Article 19(2)? For an analysis of the content of Article 19(1)(a) of the Constitution, which grants to all citizens of India the right to freedom of speech and expression. Before proceeding to analyze the relevant constitutional provisions, it may be appropriate to preface the discussion with the thought that freedom of speech is not contingent only upon the laws of a nation. The compulsion of social relations and the informal pressures of conformity exerted in a pervasive manner determine to a great extent the content and limits permissible speech in society. It is the laws, however, through their own unique methods, which reinforce social sanctions. Therefore, the Constitution, which is the fundamental law of the land, as well as the other laws which are measured on the touchstone of the Constitution, are to be interpreted, having regard inter alia to the content and permissible limits of free speech in a peaceful society. I've given Article 19(1)(a) and 19(2) an overview. For a country like ours, which is a parliamentary democracy, freedom of speech and expression is a necessary right, as well as a concomitant, for the purpose of not only ensuring a healthy democracy, but also to ensure that the citizens could be well informed and educated on governance. The dissemination of information through various media, including print and electronic media, or audiovisual form, is to ensure that the citizens are enlightened about their rights and duties, the manner in which they should conduct themselves in a democracy, and for enabling a debate on the policies and actions of the governments, and ultimately for the development of the Indian society in an egalitarian way. I have referred to some of the decisions on right to freedom of speech and expression, such as Ramesh Thappar versus State of Madras, S. Kushbu versus Kaniyammal, Shreya Singhal, etc. But the present cases, however, are not really concerned with the restrictions on the right to freedom of speech being imposed by the state. These cases are concerned with the content of Article 19(1)(a) of the Constitution, inasmuch as the grievance sought to be ventilated by the petitioner is whether there could be an inherent constitutional restriction on freedom of speech and expression on the citizens in relation to other citizens. These cases are not with regard to reasonable restrictions that could be imposed by the state or the freedom of speech and expression. Rather, what would be the content of free speech that should not be exercised as a right by an individual, which would not in any way give rise to cause of action to another citizen to seek a remedy. I have adverted to various aspects of content of speech, such as right to circulate, right to dissent, right to advertise, etc., which I need not go into. Then I have adverted to the decisions of this court with regard to hate speech. There are 2-3 decisions, such as the Pravasi Bhalai Sangathan versus Union of India, at Amish Devgat versus Union of India. I did not go into all those and have extracted various sections of the IPC, Indian Penal Code, Criminal Procedure Code, Protection of Civil Rights Act 1955, Religious Institutions Prevention of Misuse Act 1988, Scheduled Castes and Scheduled Caste Tribes, Scheduled Tribes Prevention of Atrocities Act, Representation of People Act, the Cable Television Network Regulation Act, and the rules made thereafter, Cinematograph Act, Information Technology Act, norms of journalistic conduct 2010, etc., with regard to the procedure of law. Then I have said, with regard to an aspect beyond hate speech, theoretical and doctrinal underpinnings justifying restraint on derogatory and disparaging speech may be treated to two primary factors: human dignity as a value as well as a right, the preambular goals of equality and fraternity. I have discussed about them. Reference to various cases in the international practice, that is from Canada, Australia, South Africa, Germany, and then about the Indian cases, Charu Khurana versus Union of India, Indre noise pollution, K.S. Puttaswamy versus Union of India, and then the preambular goals of equality and fraternity. Equality, liberty, and fraternity are the foundational values embedded in the preamble of our Constitution. Hate speech, in the sense discussed above, strikes at each of these foundational values by marking out a society as being unequal. It also violates fraternity of citizens from diverse backgrounds, the sine qua non of a cohesive society based on plurality and multiculturalism, such as in India, that is Bharat. Fraternity is based on the idea that citizens have reciprocal responsibilities towards one another. The term takes within its sweep inter alia the ideals of tolerance, cooperation, and mutual aid. I have given various aspects on the content of the word fraternity with reference to Subramanya Swamy versus Union of India, which is a decision of this court. And I have referred to fundamental duties under Part 4A of the Constitution as a means to check disparaging and unwarranted speech, particularly under Article 51A, Fundamental Duties. It shall be the duty of every citizen of India to uphold and protect the sovereignty, unity, and integrity of India, to promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, and regional and sectional diversities, to renounce practices derogatory to the dignity of women, to strive towards excellence in all spheres of individual and collective activity, so that the nation constantly rises to higher levels of endeavor and achievement. Fundamental duties also constitute core constitutional values for good citizenship in a democracy such as ours. The duties enumerated above enjoin all citizens with the obligation of promoting fraternity, harmony, unity, collective welfare, etc. And in the context of the speech of public functionaries and other persons of influence and celebrities, having regard to their reach, real or apparent authority, and the impact they wield on the public or on a certain section thereof, owe a duty to the citizenry at large to be more responsible and restrained in their speech. They are required to understand and measure their words, having regard to the likely consequences thereof on public sentiment and behavior, and also be aware of the example they are setting for fellow citizens to follow. In this regard, I would like to quote what I have stated at the very beginning. One of the Indian philosophers, Basaveshwara, and the English translation of it is, one should speak only when the words uttered are as pure as pearls strung on a thread, like the luster shed by a ruby, like a crystal splash that cleaves the blue, and yes, and such that the Lord, on listening to such speech, must say, yes, yes, that is true. I may also quote from verse 15 of chapter 17 of Srimad Bhagavad Gita, where the English translation says, words that do not cause distress are truthful, inoffensive, pleasing, and beneficial, are said to be included within the discipline of speech and are likened to regular recitation of the Vedic scriptures. This is called discipline of speech or Vagmaya Tapas. The discussion presented herein above is with a view to rekindle some ideas on the content of Article 19(1)(a) of the Constitution and on other pertinent issues surrounding the right to free speech guaranteed under the aforesaid article. However, as far as the substantial analysis of question number 1 is concerned, I respectfully agree with the reason and conclusion proposed by His Lordship Ram Subramaniam J. Question number 2. Can a fundamental right under Article 19 or 21 of the Constitution be claimed other than against the state or its instrumentalities? I have quoted His Lordship Justice Matthew in Keshavananda Bharati, then His Lordship Justice H.R. Khanna in ADM Jabalpur versus Shivkant Shukla, which is a dissenting opinion, and His Lordship Justice Chandrachud, as he then was in Puttaswamy's case, that the right to speech is an inalienable right of man and that the fundamental rights are only recognition of that rights. What emerges from the aforesaid decisions of this court may be culled out as follows. I have given my 3 points on that. With that primer, I shall proceed to consider whether the fundamental rights under Article 19 and 21 of the Constitution can be claimed against any person other than the state or its instrumentalities. With historical and political changes and the advent of democracy and of constitutional government, the state was created under and by a constitution and placed at a position which renders it capable of interfering with natural and common law rights. I have given a discussion on the common law rights and what are known as the natural rights and the fundamental rights. For saving the time of the court, I will not highlight on all of them, but I'll only say this. It has therefore been unequivocally declared by this court that while the content of a right recognized under Part 3 of the Constitution may coincide or overlap with the common law right, the remedies available against violation of the respective form of right operate in different spheres of law. That is, although the content of a common law right and a fundamental right may be almost identical, the remedy against violation of a common law right shall lie under common law and not under the Constitution. Similarly, the remedy against violation of a fundamental right is provided for under the Constitution itself expressly against the state under Article 92 thereof. I have given the difficulties which would be faced if a fundamental right under Article 19 and 21 is permitted to operate horizontally so as to seek the remedy by way of a writ petition before a constitutional court. I have stated all those, such as a writ petition cannot be entertained when there are disputed questions of fact. A writ petition cannot be entertained against private persons as such. But I have one submission which I have stated here when it comes to a writ petition and the operation of Article 21 in the context of habeas corpus. Before that, I'd like to give this illustration. Let me assume for the purpose of argument that the fundamental right under Article 19(1)(a) read with Article 21 is allowed to operate horizontally. A person would then be eligible to file a writ petition against another private individual or entity for violation of such right. The violation may, for instance, be a verbal attack at the aggrieved person, which may have the effect of undermining such person's dignity or reputation. Dignity and reputation are essential facets of the right to life under Article 21. At the same time, they are also recognized as common law rights, as they are fundamental attributes of human personality, which is regarded as a supreme value in common law. Common law remedies, including declarations, injunctions, and damages, are available to redress any injury to common law rights, including the right to dignity and reputation. Such rights are also statutorily recognized under the Specific Relief Act 1963 and the Indian Penal Code. Therefore, on account of availability of an alternate remedy under common law, the courts would be reluctant to entertain writ petition under Article 226 or 32, as the case may be. Then I come to the habeas corpus remedy. However, there is another aspect of the matter that requires to be discussed. A writ of habeas corpus is an order directing the person who has detained another to produce the detainee before the court in order for the court to ascertain on what ground or for what reason he has been confined. A writ of habeas corpus is granted ex debitio justitiae, and the applicant must only demonstrate prima facie unlawful detention of himself or any other person. If there is no justification for the detention and the same is unlawful, a writ is issued as of right. The importance of a writ of habeas corpus is the duty being cast on a constitutional court to issue the writ to safeguard the freedom of a citizen against illegal and arbitrary detention. In my humble view, an illegal detention is a violation of Article 21 of the Constitution, irrespective of whether the detention is by the state or by a private person. Therefore, in the context of the remedy of writ of habeas corpus, which is available under Article 226 as well as under Article 32 of the Constitution, I have said that the Article 21 would operate horizontally. I have cited certain decisions where this court has exercised jurisdiction under Article 32, read with Article 142, and granted compensation in certain matters where Article 21 was invoked. In light of the aforesaid discussion, question number 2 is answered as follows. The rights in the realm of common law, which may be similar or identical in their content to the fundamental rights under Article 19 or 21, operate horizontally. However, the fundamental rights under Articles 19 and 21 may not be justiciable horizontally before the constitutional courts, except those rights which have been statutorily recognized and in accordance with the applicable law. However, they may be the basis for seeking common law remedies, but a remedy in the form of writ of habeas corpus, if sought against a private person on the basis of Article 21 of the Constitution, can be before a constitutional court, that is by way of Article 226 before the High Court or Article 32 read with Article 142 before the Supreme Court. Question number 3, whether the state is under a duty to affirmatively protect the rights of a citizen under Article 21 of the Constitution of India, even against a threat to the liberty of a citizen by the acts or omissions of another citizen or private agency. In that context, I have referred to certain decisions of this court in the context of Article 21, where compensation, etc., was granted by this court and the writ petitions were entertained. And I have given that in order to protect life and liberty, what the role of the state would be, where inaction on the part of the state to contain a hostile situation between private actors would have the effect of depriving persons of the right to life and liberty, where the state had failed to carry out its obligation under a statute or a policy or scheme, and such failure could have the effect of depriving persons of their right to life and liberty. It is therefore clear that the acknowledgement of this court of the duty of state under Article 21 only pertains to a negative duty, not to deprive a person of his right to liberty and life, except in accordance with law. This court has not recognized an affirmative duty of the state under Article 21 of the Constitution to protect the rights of a citizen against a threat to the liberty of a citizen by the acts or omission of another citizen or private agency. In light of the above discussion, question number 3 is answered accordingly. Then, can a statement made by a minister, next, question number 4, can a statement made by a minister traceable to any affairs of the state or protecting the government be attributed vicariously to the government itself, especially in view of the principle of collective responsibility? A minister may make statement in 2 capacities. First, in his personal capacity. Second, in his official capacity and as a delegate of the government. It is no brainer that in respect of the former category of statements, no vicarious liability may be attributed to the government itself. The latter category of statements may be traceable to any affair of the state or may be made with a view to protect the government. If such statements are disparaging or derogatory and represents not only the personal views of the individual minister making them, but also embody the views of the government, then such statements can be attributed vicariously to the government itself, especially in view of the principle of collective responsibility. In other words, if such statements are endorsed not only the statements made by an individual minister, but also reflective of the government's stance, such statements may be attributed vicariously to the government. However, if such statements are stray opinions of an individual minister and are not consistent with the views of the government, then they shall be attributable to the minister personally and not to the government. Accordingly, I have answered question number 4. Question number 5, whether a statement by a minister inconsistent with the rights of a citizen under Part 3 of the Constitution constitutes a violation of such constitutional rights and is actionable as constitutional tort. Where public law and private law are in theory treated as analytically different, in practice the divide between the two spheres is often blurred. As a result, ideas, concepts, and devices from one sphere influence the other. Such an intermingling has given rise to the doctrine of horizontal effects, as discussed herein above, wherein a constitutional directive or norm, fundamental right, is interpreted by courts to apply between individuals. Then I have given, in the context of constitutional tort, whether the writ petition is maintainable and with regard to the principles which would apply to entertainment of writ petitions. In this regard, I have referred to Article 294B of the Constitution, which declares that liability of the union government or the state government may arise out of any contract or otherwise. The word otherwise implies that the state liability may arise for tortious acts as well. Article 300 enables institution of appropriate proceedings against the government for enforcing such liability. Article 21 has played a significant role in shaping the law on tortious liability of the government. This court has asserted that the concept of sovereign functions, which acts as an exception to attracting tortious liability, ends where Article 21 begins. Therefore, this court has been willing to defend life and liberty of persons against state lawlessness by holding that where Article 21 is violated, the state has to pay compensation, and the concept of sovereign function does not prevail in this area. This is particularly so in public interest litigation. I have referred to these cases, including Nilapati Behera versus State of Orissa and other cases, Rudal Shah, D.K. Pashu, etc. In light of the above discussion, it is observed that it is not prudent to treat all cases where a statement made by a public functionary resulting in harm or loss to a person or citizen as a constitutional tort. Regard must be had in every case to the nature of resultant harm or loss. Further, it is to be noted that even the cases cited above have permitted treating an act or omission as a constitutional tort where there has been an infraction of fundamental right as a direct result of such act or omission. Therefore, the causal connection between the act or omission and the resultant infraction of fundamental right is central to any determination of an action of constitutional tort. Therefore, it is observed that presently invocation of writ jurisdiction to grant damages by treating acts of omissions of agencies of the state as constitutional torts must be an exception rather than a rule. The remedy before a competent court or under criminal law is in any case available as per existing legal framework. Accordingly, I have answered. In light of the above discussion as well as the answers given to the questions referred, the following other conclusions are drawn. It is for the Parliament in its wisdom to enact a legislation or code to restrain citizens in general and public functionaries in particular from making disparaging or vitriolic remarks against fellow citizens, having regard to the distinct and strict parameters of Article 92 and bearing in mind the freedom under Article 19(1)(a) of the Constitution. Hence, I am not inclined to issue any guideline in this regard, but the observations made herein above may be borne in mind. B. It is also for the respective political parties to regulate and control the action and speech of its functionaries and members. This could be through enactment of a code of conduct, which would prescribe the limits of permissible speech by functionaries and members of the respective political parties. C. Any citizen who is prejudiced by any form of attack as a result of speech or expression through any medium targeted against her or him, or by speech which constitutes within quotes hate speech or any species thereof, whether such attack or speech is by a public functionary or otherwise, may approach the court of law under criminal and civil statutes and seek appropriate remedies. Wherever permissible, civil remedies in the nature of declaratory remedies, injunctions, as well as pecuniary damages may be awarded as prescribed under relevant statutes. However, answers given to question numbers 4 and 5 may have a bearing in the context of collective responsibility of government and constitutional tort. Writ petition and civil petition are directed to be listed before an appropriate bench after seeking orders of Honorable the Chief Justice of India. I must thank my honorable brother judges and the audience for your attention, particularly the lawyers. One or two typos are
Thank you. At the outset, I express my gratitude to my learned brother, Justice Nadir, and the brothers for giving me an opportunity to author this judgment. Though it is authored by one of us, I am grateful to my learned brothers for the inputs, valuable inputs without which the judgment could not have been complete. Though initially 9 issues were framed, taking into consideration the arguments advanced on both the sides, we have reframed 6 questions. I'm reading them. The first was whether the power available to the central government under subsection 2 of section 26 of the RBI Act can be restricted to mean that it can be exercised only for one or some series of banknotes and not all series, in view of the word any appearing before the word series in the subsection. Specifically so when on earlier 2 occasions, the demonetization exercise was done through the plenary legislations. Then 2, in the event it is held that the power under subsection 2 of section 26 of the RBI Act is construed to mean that it can be exercised in respect of all series of banknotes, whether the power vested with the central government under the said subsection would amount to conferring excessive delegation and as such liable to be struck down. And 3, as to whether the impugn notification dated 8th of November 2016 is liable to be struck down on the ground that the decision-making process is flawed in law. In the 4th, as to whether the impugn notification dated 8th November 2016 is liable to be struck down applying the test of proportionality. And 5, as to whether the period provided for exchange of notes by the impugn notification dated 8th November 2016 can be said to be unreasonable. And the 6th one, as to whether the RBI has an independent power under subsection 2 of section 4 of the 2017 Act in isolation of provisions of section 3 and section 4(1) thereof to accept the demonetized notes beyond the period specified in notification issued under subsection 1 of section 4. Insofar as the first issue is concerned, we have considered the judgments of constitutional benches in the case of the Chief Inspector of Mines versus Lala Karamchand Thapar and Banwarilal Agrawal versus State of Bihar. And the third one, Tej Kiran Jain and others versus Sanjeeva Reddy and various other judgments of the various bench strengths, wherein word any has been interpreted. And it has been held that the word any has to be construed in context to the statutory provisions. And then the second principle which we have considered is the purposive construction. We have referred to the Constitution Bench judgments in the case of M. Petia and others. Then Chief Justice of Andhra Pradesh versus V.A. Dikshitilu and others, and Tinsukia Electric Supply Company Limited versus State of Assam, apart from the other judgments. We have held that the modern trend is of pragmatic and not pedantic interpretation. The interpretation leading to absurdity and which renders a provision to be futility has to be avoided. Any interpretation which advances the purpose and object of the legislation has to be preferred when 2 constructions are possible of particular provision. And applying these principles, we have held that a restrictive meaning cannot be given to word any. And insofar as issue number 2 is concerned, we again refer to the Constitution Bench judgments in Hamdard Dawakhana, Tarakchand, Ratanchand Bantia, and Birla Cotton and Spinning and Weaving Mills. We have held that for finding out the policy and guidance, a resource can be added to various provisions of the Act, including the preamble, the purpose of the Act, and what is necessary is that the parent statute must consist of an essential legislative function, that is determination of legislative policy, and it is permissible in view of the multifarious activities that it is necessary for the legislature to delegate the working of details. When we have considered the status of the RBI, we have referred to the judgment of the Constitution Bench in Joseph Kurila, then the judgment authored by my learned brother Justice Ram Subramanian in Internet College, and we have specifically emphasized on the primary role of the RBI in issuance and regulations of banknotes, then its important role in monetary and economic policy of the country. Then we also considered the nature of body to whom the delegation is made. In the present case, the delegation is made to the central government, which is answerable to parliament, and parliaments are in fact are answerable to the citizens of the country. In this respect, we are referred to the judgment of the Constitution Bench in Birla Cotton. Then in the case of Bharat Chand itself, when clause B of subsection 2 of section 5 was held unconstitutional, in the very same judgment, the Constitution Bench has held clause A of subsection 2 of section 5 to be constitutional on the ground that it provided that the administrator can take action after consultation with the RBI, and therefore there was self-imposed provision which required the RBI to be taken into consideration. Applying the same principle, we have held that in the present case also, the central government is required to take the action after recommendation of the central board, and therefore there is an inbuilt safeguard. Insofar as third issue is concerned, we have basically relied on the judgment in the case of Tata Cellular, wherein the scope of judicial interference in matters pertaining to is very limited. Then we have further referred to various Constitution Bench judgments which are specifically dealing with interference insofar as economic policy is concerned. The judgment in Prague Ice and Oil Mills versus Union of India rendered by 7 judges. Then R.K. Garg versus Union of India. Then Shri Sitaram Sugar Company versus Union, and which has been held that there has to be a great deal of restraint insofar as interference in the matters pertaining to economic policy is concerned. The court cannot substitute its judgment for that of the legislature or the executive. It does not supplant the feel of the experts with its own views. Then we have also scrutinized the record, and after examining the record, we have found that the judicial decision-making process cannot be flawed merely because the procedure has emanated from the central government. We have construed that the term recommendation has to be construed in the context of the statutory scheme, and what is contemplated is a consultative process. And from the record, it appears that there was a consultation between the RBI and the central government over a last period of 6 months. Then, insofar as the fourth issue is concerned, we have considered the 4-pronged test held in modern dental education. One, as to whether the action was designated for a proper purpose. We find that the 3 purposes are proper purposes, and whether there was a reasonable nexus of the measure with the purpose sought to be achieved. And we have held that there was a reasonable nexus. Then, insofar as the third test with regard to alternate measures is concerned, there cannot be any alternate measures for the action which is thought to be done by demonetization. Then the fourth one is whether there was proper relation between the importance of the purpose to be achieved and the limitations on the constitutional rights. And applying all these 4 tests, we have held that the action cannot be hit by the doctrine of proportionality. Then issue number 5, with regard to reasonableness of period is concerned, we have considered that in the 1978 Act, the period provided was only 3 days, and which was extendable by a further period of 5 days. And this has been found to be a reasonable period in the case of Jayantilal Shah by the Constitution Bench. In the present case, the period provided is 52 days, and therefore, applying the principles laid therein, it cannot be said to be an unreasonable period. Then, insofar as issue number 6 is concerned, we have held that the entire scheme of section 3 and 4 has to be considered. The powers under the provision of subsection 2 of section 4 cannot be construed in isolation, and therefore the RBI does not have an independent power. Insofar as hardship is concerned, we have referred to the judgment in the case of R.K. Garg and Sonia Bhatia, and we also considered that it is not relevant as to whether the objective thought has been achieved or not. So what is required is that there has to be an objective which is for the proper purposes, and there has to be a reasonable nexus with the measure and the object to be achieved. We also held that the we cannot direct the central government to exercise its powers under subsection 2. And it is for the central government to exercise such a power if it finds that the exigency so arise. Accordingly, we have answered the reference as under 1. The power available to the central government under subsection 2 of section 26 of the RBI Act cannot be restricted to mean that it can be exercised only for one or some series of banknotes and not for all series of banknotes. The power can be exercised for all series of banknotes merely because on 2 earlier occasions, the demonetization exercise was by plenary legislations. It cannot be held that such a power would not be available to the central government under subsection 2 of section 26 of the RBI Act. Then second, subsection 2 of section 26 of the RBI Act does not provide for excessive delegation inasmuch as there is an inbuilt safeguard that such a power has to be exercised on the recommendation of the central board. As such, subsection 2 of section 26 of the RBI Act is not liable to be struck down on the said ground. In 3, the impute notification dated 8th November 2016 does not suffer from any flaws in the decision-making process. 4, the impute notification dated 8th November 2016 satisfies the test of proportionality and as such cannot be struck down on the said ground. 5, the period provided for exchange of notes while the impute notification dated 8th November 2016 cannot be said to be unreasonable. And 6, the RBI does not possess independent power under subsection 2 of section 4 of the 2017 Act in isolation of the provisions of section 3 and 4(1) thereof to accept the demonetized notes beyond the period specified in notification issued under subsection 1, section 4 of the 2017 Act. Having answered the reference, we direct the registry to place the matter before the Honorable the Chief Justice of India for placing it before the appropriate benches. Needless to state that all other contentions are kept open to be considered by the benches before which the matter would be placed. Before parting with the judgment, we place on record our deep appreciation for the valuable assistance rendered by Sri R. Venkatramani, the Learned Attorney General, Sri P. Chidambaram, Sri Shyam Diwan, and Sri Jaideep Gupta, Learned Counsel, and all other counsels appearing for the parties.
I've had the benefit of reading the judgment proposed by His Lordship B.R. Gawai J. However, I wish to differ on the reasoning and conclusions arrived at in his judgment with regard to exercise of power by the central government in subsection 2 of section 26 of the Reserve Bank of India Act 1934, hereinafter referred to as the Act for the sake of brevity, by issuance of the impute notification dated 8th November 2016, hence my separate judgment. By way of preface, I state that the judgment proposed by His Lordship Gawai J does not recognize the essential fact that the Act does not envisage initiation of demonetization of banknotes by the central government. Subsection 2 of Section 26 of the Act contemplates demonetization of banknotes at the instance of the Central Board of the Reserve Bank of India, hereinafter referred to as the Act, as the bank. Hence, if demonetization is to be initiated by the central government, such power is derived from entry 36 of list 1 of the 7th schedule to the Constitution, which speaks of currency, coinage, and legal tender foreign exchange. I quoted the 7 issues, judgments, which were, the references, order dated 16th December 2016, where 9 questions were referred. His Lordship Gawai J has reframed the questions referred to this Constitution bench and culled out 6 questions, which have been answered in the erudite judgment proposed by him. My views on each of such questions, as contrasted with those of his lordships, have been expressed in a tabular form hereunder for easy reference. It is at the head, I have put that. And I have stated about the overview regarding the importance of the Reserve Bank of India and the Reserve Bank of India Act 1934. And I have spoken about the history and instances of demonetization the world over, in France, in the United States of America, Britain, Congo, Ghana, Nigeria, Myanmar, Russia, Venezuela, Zimbabwe, and the history of demonetization in India in the two periods of 1947 and 1978. While speaking about the Reserve Bank of India being the bulwark of the Indian economy, I have quoted Internet and Mobile Association of India versus RBI, wherein one of us, we, Ram Subrahmanyam J, while dealing with the regulation of cryptocurrency and virtual currency, highlighted the importance of the bank in the Indian economy. Then I've spoken about the economic and fiscal policies interference by the court and cited the judgments. What emerges from an understanding of the decisions referred to above or the subject of judicial review of economic policy may be culled out as under: 1. That the court is not to sit in judgment over the merits of economic or financial policy. 2. That the scope of interference by a court is limited to instances where the impugned scheme or legislation in the economic arena has been enacted in violation of any constitutional or statutory provisions. 3. That the court may not undertake a foray into the merits, demerits, sufficiency or lack thereof, success in realizing the objectives, etc., of an economic policy, as such an analysis is the prerogative of the government in consultation with experts in the field. Being mindful of the limited scope of judicial review permissible in matters concerning economic policy decisions, I shall limit my examination of the matter to such extent as is necessary for the purpose of determining whether the process concluding in the issuance of the impugned notification was correct or as being contrary to subsection 2 of section 26 of the Act and allied aspects of the case. It may be stated at this juncture that the said aspect of the matter is not one of form, but of substance. Therefore, examining this aspect of the matter would not amount to interfering with or sitting in judgment over the merits of the policy of demonetization, and is therefore well within the limits of the Lakshman Rekha that this court has carefully drawn for itself. Then I have analyzed section 26 of the Act interpretation. There I have made again a table with a view to lend perspective to the issue with the discussion to follow. A bird's eye view of my analysis and conclusion has been expressed in a tabular form. The parameters for distinction. Then second, when the proposal for demonetization originates by way of a recommendation by the Central Board of the Bank. And the third is when the proposal for demonetization originates from the central government, as in the instant case. In that, I would say role of the central government, and the second parameter is role of the bank. The third parameter is extent of demonetization that may be proposed and carried out. Fourth, considerations for proposed measures of demonetization, illustrative. 5, process or route to be followed to carry out demonetization. And 6, applicability of subsection 2 of section 26 of the Reserve Bank of India Act. There I have stated that when the demonetization originates by way of a recommendation by the Central Board of the Bank, it is section 26(2) which applies. But when the proposal for demonetization originates from the central government, as in the instant case, it is not under section 26(2) of the Act. It is to be by way of a legislation. And if legislation is not the way, in the sense there is need for secrecy, then it is ordinance. Since I have accepted the contention of the learned Attorney General appearing for Union of India in relation to the power of the central government for initiating the process of demonetization, the next question would be whether the central government can, on initiating the process of demonetization, proceed to issue a gazette notification to demonetize any or all series of any or all denomination of banknotes on the strength of subsection 2 of section 26 of the Act. Consideration of this issue would also answer the contention of learned senior counsel for the petitioners regarding subsection 2 of section 26 of the Act being unguided and arbitrary in nature and hence unconstitutional. To this end, the following aspects have to be examined. A. Whether demonetization can be initiated and carried out by the central government by issuing a notification in the Gazette of India as per subsection 2 of section 26 of the Act. B. Extent of the central government's power to carry out demonetization, that is, whether all series of all denominations may be demonetized. As held herein before, the proposal for demonetization can emanate either from the central government or from the Central Board of the Bank. It is, however, necessary to contrast the proposal for demonetization initiated by the central government with that initiated by the Central Board of the Bank. When the bank recommends demonetization, it is, in my view, only for a particular series of banknotes of a particular denomination, as specified in the recommendation made under subsection 2 of section 26 of the Act. The word any in subsection 2 cannot be read to mean all. If read as specified or particular as against all, in my view, it would not suffer from arbitrariness or suffer from unguided discretion being given to the central bank of the bank. On the other hand, in my view, the central government has the power to demonetize all series of banknotes of all denominations if the need for such a measure arises. It cannot be restricted to such powers in such manner as the Central Board of the Bank is under the above provision. This is because such power is not exercised under subsection 2 of section 26 of the Act, but is exercised notwithstanding the said provision by the central government. Therefore, demonetization of banknotes at the behest of the central government is a far more serious issue, having wider ramifications on the economy and on the citizens, as compared to demonetization of banknotes of a given series of a given denomination on the recommendation of the Central Board of the Bank by issuance of a gazette notification by the central government. Therefore, in my considered view, the powers of the central government being vast, the same have to be exercised only through a plenary legislation or a legislative process rather than by an executive act by the issuance of a notification in the Gazette of India. It is necessary that the Parliament, which consists of the representatives of the people of this country, discusses the matter and thereafter approves and supports the implementation of the scheme of demonetization. The central government, as already noted, could have several compulsions for initiating demonetization of the banknotes already in circulation in the economy, and it could do so even in the absence of a recommendation as per subsection 2 of section 26 Act of the Central Board of the Bank. On its bank to demonetize the banknotes, the advice or opinion of the central bank, which has to be consulted, may not always be in support of the proposal of the central government, as in the year 1978. Central Board may give a negative opinion or a concurring opinion. In either of the situations, the central government may proceed to demonetize the banknotes, but only through a legislative process, either through an ordinance followed by a legislation if the Parliament is not in session, or by a plenary legislation before the Parliament, and depending upon the passage of the bill as an act, carry out its proposal of demonetization. And they have given the reasons for the same. I have said why it should be through the legislative process. A parliament is often referred to as a nation in miniature. It is the basis for democracy. A parliament provides representation of the people of a country and makes their voices heard. Without a parliament, a democracy cannot thrive. Every democratic country needs a parliament for the smooth conduct of its governance and to give meaning to democracy in the true sense. Parliament, which is the center of our democracy, cannot be left aloof in a matter of such importance. Its views on the subject of demonetization are critical and of utmost importance. Nobody states that the impugned Gazette notification dated 8th November 2016 of the central government was published on the initiation of a proposal of demonetization by the Central Board of the Bank. Proposal for demonetization was initiated by the central government by a letter dated 7th November 2016, addressed by the Finance Secretary to the Governor of the Bank. The central government, having obtained the advice of the bank on its proposal, proceeded to issue the Gazette notification on the very next day, dated 8th November 2016. The same was followed by an ordinance and thereafter an enactment was passed. Then in the incident case, I have said whether the central board of the bank was in a position to visualize the objectives in the incident case. Under what circumstances the central government was consulted by the central board of the bank was consulted by the central government. Then deciphering the plain meaning of subsection 2 of section 26. I said the plain meaning has to be given to this provision. Then I have said that section 3 of the act, which was also in the clause 3 of the ordinance itself, is writ with inherent contradiction because it says notwithstanding anything contained in the Reserve Bank of India Act 1934 or any other law for the time being in force, and then says the 8th November 2016 notification issued under subsection 2 of 26. Section 26. Therefore, there is an inherent contradiction there in the provision itself. Then I have gone to the affidavits and record of the case, and the Government of India as well as the Reserve Bank of India, each of them gave 4 documents they have been looked into. And on looking into the records, I find that the use of the words or phrases such as desired by the central government had recommended the withdrawal of legal tender of existing 500 and rupees 1000 notes. Recommendation has been obtained, etc. are self-explanatory. This demonstrates that there was no independent application of mind by the bank. Neither was there any time for the bank to apply its mind in such a serious issue. This observation is being made having regard to the fact that the entire exercise of demonetization of all series of banknotes of rupees 500 and rupees 1000 was carried out in 24 hours. A situation where an independent authority such as the bank, based on its own appreciation of the economic climate of the country, recommends a measure to the central government must be contrasted with another situation where a measure which originates from the central government is simply placed before such independent authority for seeking advice or opinion on such proposed measure. Proposal of the central government on a certain scheme having serious economic ramification has to be placed before the bank to seek its expert opinion as to its viability of such a scheme. The bank as an expert body may render advice on such a proposal and on some occasions may even concur with the same. However, even such concurrence to a proposal originating from the central government is not akin to an original recommendation of the Central Board of the Bank within the meaning of Section 26, subsection 2 of the Act. Then I have gone through the affidavits of the Union of India and contrasted it with the affidavits of the bank. On a close reading of the notification dated 8th November 2016, in juxtaposition with the records, the following aspects emerge. One aspect of the matter which emerges with no ambiguity is that the proposal for demonetization originated from the central government by way of its letter addressed to the bank dated 7th November 2016. This aspect forms the central plank of the controversy at hand. That the recommendation did not originate from the bank under subsection 2 of section 26 of the Act, but was obtained from the bank in the form of an opinion on the proposal for demonetization submitted by the central government. Such an opinion could not be considered to be a recommendation as required by the central government in order to proceed under subsection 2 of section 26 of the Act. Even if it is assumed for the sake of argument that the said opinion was in fact a recommendation under subsection 2 of section 26 of the Act, in light of the interpretation given by me herein above to the phrase any series or any denomination, means specified series or specified denomination, the recommendation itself is void inasmuch as it pertained to demonetization of all series of banknotes of denomination values of rupees 500 and 1000. As has already been observed, the term any as appearing in subsection 2 of section 26 of the Act cannot be interpreted to mean all, as such an interpretation would vest unguided and expansive discretion with the central bank of the board, or the central board of the bank. And legal principles applicable to the case, I have said that to do a thing a particular way or not to do at all, that is Taylor versus Taylor, Nazir Ahmed versus King Emperor, and the various cases of this court on the said principle are cited. What emerges from the above discussion is that when a statute contemplates a specific procedure to be adhered to in order to arrive at a desired end, such procedure cannot be substituted by an alternative procedure which is not contemplated under the statute. Further, if an action is to be carried out by way of issuance of a particular statutory instrument on the basis of certain requirements, such action cannot be validly carried out by issuance of an instrument when the same is not contemplated under the Act. This is particularly so when the instrument enacted stands on a different footing than the one meant to be enacted. Then I have said something about the records. Hence, in my considered view, the action of demonetization initiated by the central government by issuance of the improved notification dated 8th November 2016 was an exercise of power contrary to law and therefore unlawful. Consequently, the 2016 Ordinance and 2017 Act are also unlawful. But having regard to the fact that demonetization process was given effect to from 8th November 2016 onwards, the status quo ante cannot be restored at this point of time. What relief may be awarded in the present case? In view of the above conclusion, the question of molding the relief shall now be considered. According to the petitioners, around 86% of the volume of currency notes of the total currency in circulation in the Indian economy was demonetized. They also stated that the people of India were exposed to undue hardship owing to the lack of financial resources and had to undergo not only a severe financial crunch, but were also exposed to other socio-economic and psychological hardships. The problems associated with the measure of demonetization would make one wonder whether the central board of the bank had visualized the consequences that would follow, whether the central board of the bank had attempted to take note of the adverse effects of demonetization of such a large volume of banknotes in circulation. The objective of the central government may have been sound, just and proper, but the manner in which the said objectives were achieved and the procedure followed for the same, in my view, was not in accordance with law, having regard to the interpretation given above. It has also been brought on record that around 98% of the value of the demonetized currency have been exchanged for banknotes, which continues to be legal tender. Also, a new series of banknotes of rupees 2000 was released by the bank. This would suggest that the measure itself may not have proved to be as effective as it was hoped to be. However, this court does not base its decision on the legality of legislation, where the effectiveness of such action in achieving the stated objectives. Therefore, it is clarified that any relief molded in the present case is divorce considerations of such success of the measure. Learned Attorney General, appearing on behalf of the Union of India, stated that the issues raised in these petitions have become infructuous and wholly academic, as the action of demonetization has been acted upon, and therefore the present cases are only of academic significance. It is necessary to examine the nature of relief that could be molded by the court in this matter. Thereafter, citing Bommai, Golaknath, Orissa Cement, etc., I have given my conclusions with regard to section 26(2) and the interpretation that it has to be through a legislative process. And in that summary, subpara 9, I have said, the opinion of the Central Board of the Bank ought to be an independent and frank opinion after a meaningful discussion by the Central Board, which ought to be given its due weightage, having regard to the ramifications it may have on the Indian economy and the citizens of India, although it may not be binding on the central government. On receipt of a negative opinion from the Central Board of the Bank, the central government, which has initiated the demonetization process, may still intend to go ahead with the said process after weighing the pros and cons only by means of an ordinance and or parliamentary legislation, but not by issuance of the Gazette notification. In other words, the central government in such circumstances cannot resort to exercise of power under subsection 2 of section 26 of the Act by issuing a notification in the Gazette of India as if it were exercising executive powers. Even if the Central Board of the Bank concurs with the proposal of the central government, the central government would have to undertake a legislative process and not carry out the measure simply by issuing a Gazette notification. In view of the aforesaid conclusions, I am of the considered view that the impugn notification dated 8th November 2016 issued under subsection 2 of section 26 of the Act is unlawful. In the circumstances, the action of demonetization of all currency notes of rupees 500 and rupees 1000 is vitiated. Further, the subsequent ordinance of 2016 and Act of 2017 incorporating the terms of the impugn notification are also unlawful. However, having regard to the fact that the impugn notification dated 8th November 2016 and the Act have been acted upon, the declaration of law made herein would apply prospectively and would not affect any action taken by the central government or the bank pursuant to the issuance of the notification dated 8th November 2016. This direction is being issued having regard to Article 142 of the Constitution of India. Hence, no relief is being granted to the individual matters. In view of the above conclusions, I do not think it is necessary to answer the other questions raised in the reference order. Before parting, I wish to observe that demonetization was an initiative of the central government targeted to address disparate evils plaguing the nation's economy, including practices of hoarding black money, counterfeiting, which in turn enable even greater evils, including terror funding, drug trafficking, emergence of a parallel economy, money laundering, including Hawala transactions. It is beyond the pale of doubt that such a measure, which was aimed at eliminating these depraved practices, was well intentioned. The measure is reflective of concern for the economic health and security of the country and demonstrates foresight. At no point of time has any suggestion been made that the measure was motivated by anything but the best intentions and noble objects for the betterment of the nation. The measure has been regarded as unlawful only on a purely legalistic analysis of the relevant provisions of the Act and not on the objects of demonetization. In view of the answers given by me to question number 1 of the reference order, I do not deem it necessary to answer all other questions of the reference order or even the questions reframed by His Lordship B.R. Gawai J. during the course of the judgment, except to the extent discussed above. In the result, the writ petitions, special leave petitions, and transfer petitions are disposed of in the aforesaid terms. All pending applications accordingly stand disposed. I would like to acknowledge and place on record my appreciation It's one typographical error. 1934 it has come, 1934 it must be. Were given in.
Come back, don't go now.
Test 1 2 3 1 2 3. Port 4 test 1 2 3 1 2 3. Port 4 test 1 2 3 1 2 3.
Clear, clear.
Port 4 test 1 2 3 1 2 3.
Check.
1 2 3 4 5 6 7 8. 1 2 3 4 5 6 7 8. Testing done.
Check. Done.
Port 1 2 3 4 5 6 7 8 9 10. Testing.
So I'm just submitting a short written note about my submissions. Lordship may consider.
Give it, I mean, it doesn't really matter. Mountaineers, what, 1 more 5 will make no difference. Yes, yes.
Yes, Manoj, I'll now proceed rapidly. I wish to first take up the point on which yesterday we closed, which were 2 questions which were put to me by Justice Rastogi.
Yeah.
The first question was, as I understood it, with regard to facts and in the context of some of the reports that I had highlighted. And the question was, how do we ascertain facts in a situation or in a case such as this? This was one aspect. The second corollary was that assuming that a case on the facts is made out, how would that have any bearing with regard to the constitutional vires of the statute, which is being tested here before the court? Because regardless, do we not have to look at the statutory provisions alone for ascertaining as to whether there's some infirmity in the context of it not being implemented or being implemented in a manner which is deficient? Now, may I just supply my answers first and then just provide the judgments and the authorities in support? The first answer is that as far as ascertaining of facts in Article 32 and 226 petitions is concerned, and also particularly with regard to public interest litigations, the rule adopted by this court is that the facts have to be established generally on affidavit. That's one. A second corollary is that affidavit can extend to photographs and newspaper articles itself. And when I'm talking about newspaper articles, I don't mean the affidavit of the journalist or the author of the article. I'm talking about someone who's approaching the court in the public interest. So this will be the first measure or the first step in establishing facts. Once that is done, and if the court is satisfied about the facts, only if you're satisfied about the facts made out, that this requires an answer, then there is under our system the need for a counter affidavit or a reply affidavit contesting the situations. That again under 226 and 32 is done by way of affidavit. In the facts of the present case now, the situation is this. Right from 2017, when the Act came into force, we have placed on record reports authored by people who were authored by PETA generally, based on, as I indicated yesterday, ground investigations.
No counter affidavit is filed.
And there is no counter affidavit.
No notice given to us on these applications.
So on every application, the writ petition is filed in 2017. The writ petition is filed in 2017. There is obviously notice on the writ petition. There's no counter affidavit in the 2017 report.
Which
one
petition are you talking about?
This is PETA. I'm only on one, which is, I'll give you the number, 1011 of 2020. 2017. So then there's a mistake you made on the cover.
The material you're lying on is produced in that?
Sorry?
Material you're lying on is produced in that?
Yes. So the answer is yes. And I'll just qualify that answer. The petition having been filed in 2017, and I've given you those details, so I'm going to just flag them. The petition having been filed in 2017, the 2017 report is part of the petition, right? However, for subsequent years, 18 applications have been filed, they have been brought on the record, and I mean, it's too late in the day for the state of Tamil Nadu, which has not filed a reply, to now say no notice was issued. Once the affidavits are filed and once the material is filed, if they want to contest it under our court and this system, we do not. We file an additional document, it's taken on the record, and if they wish to file a reply, they file a reply. If they choose not to file a reply, too bad. Now, this is the state of the record which we have. Yes. Now, please just, have you changed the number? Yes. Just now, give it to them as well. Now, we've put the authorities in this so that I don't have to refer to the books, etc. And your lordships will just pick this up. I put 3 or 4 judgments in this, just for your convenience. I'll go rapidly through this. The second point, while this is being marked and handed over, let me just indicate. The settled law in this court appears to be that what has to be seen is the effect of the law, the consequence of the law, not the facial phraseology used by the law. So therefore, to judge consequence and effect, facts have to be looked at, not the language of the statute alone. This appears to be the broad position, briefly to answer the question. Now we start with Mr. Sirvai's Constitutional Law of India, the 1991, which is the last edition. Please go directly to page 3 of the compilation. Para 9.355. Public interest litigation is litigation between, I'm reading the marginal note, opposing parties to determine their rights. Matter in the public interest litigation comes before the courts is normally by a petitioner presenting a petition supported by one or more affidavits. Counter affidavits are filed, and if necessary, affidavits in rejoinder and surrejoinder are filed. But having regard to the very large number of people who may be involved, the enforcement of strict rules of proof are relaxed, so that the power of the court to grant relief is not nullified in a practical sense. If lakhs of people are slum dwellers and pavement dwellers, proof in respect of every person to show the injury caused to him or her would prevent a court from effectively granting any relief. Therefore, slum dwellers and pavement dwellers were classified in broad categories. The circumstances under which the trial court granted the injunction, as stated in the judgment of the trial court, were taken into account. Photographs of the demolition or unauthorized structures occupied by the slum dwellers, published in newspapers, were admitted in evidence, it being left to the person opposing the petition to controvert that fact. In order to ascertain the factual position as regards the different categories of pavement dwellers and slum dwellers, the court appointed an officer to make a report. The report was admitted, etc. Relaxation of strict rules of evidence. It goes on and it talks about a counter this thing. So this is at least Sirvai's understanding way back in 1991, when public interest litigation relatively was in its infancy. Now I come to the second point. The second point is, and I'll just state the point. Your lordships had occasion to judge as to whether the law is to be examined on its face, or the language used of the statute, or the effect and consequence. Now, constitution benches, which I'm going to rapidly take you through, have held you have to look at the consequence and the effect and not the phraseology of the law. Now, let me give you an example. In the Bennett-Coleman case, for example, there was a tax on newsprint. That was considered, the tax on newsprint was not directly affecting 19(1)(a), etc. But the whole point was that, look, the newspaper size will shrink, advertisement will be impacted, and free speech indirectly will be impacted. I'm just explaining the context. Now, in the Article 21 context, this is the paragraph I read in the opening, so I'm just going to flag it here. Page 5 is Maneka Gandhi, 7 judges of this court. The relevant paragraph, which I had read earlier, so I won't read it this time, but it's in a 21 context, is at page 12. Page 12 of this compilation. It's the last 7 or 8 lines in para 19 and the first 6 or 7 lines in para 20. And the language which is used is direct and inevitable consequence of state action. So in Maneka Gandhi, the earlier paragraphs go to R.C. Cooper, they go to the Bennett-Coleman case, and then when this court speaks in Maneka Gandhi, it's about 10 lines from the top at 299. That's the print page 299, page 12. It is possible that in a given case, the pith and substance of state action may deal with a particular fundamental right, but its direct and inevitable effect may be another fundamental right. In that case, the state action would have to meet the challenge of the latter fundamental. I'm so sorry.
Sorry to interrupt you.
Yes.
There is a subtle distinction between
Yes.
the direct effect, the substantive effect of a law,
Yeah.
and the possibility that the law may not be followed on the ground,
Yeah.
and that it may be abused.
Right.
They are two different things.
I think so.
You're
You're
absolutely
right.
correct.
So let me just answer that. The direct impact of this law, let me tell you, is to continue cruelty insofar as bulls are concerned. That's my case. If you're not really persuaded by that case, then I think the consequences will be different.
It's a because as to whether how it is being worked on the ground is a different thing that cannot be taken into consideration.
That has to be or ought to be. I can only say ought to be because you have material from 5 years on the record of this court, documented and supported by affidavit, which shows extreme cruelty and brutality in the conduct of Jallikattu only for certain incidents where we sent our people. So the cruelty is much greater because it extends. Our reports are for 5 days here, 1 week there. But the reports regarding deaths are taken for the entire, what I would describe as the season, the first 5 months of the calendar year, etc. So I'll come to that. But here, the direct and inevitable consequence, therefore, to complete the sentence, is continuing cruelty. The continuation of a blood sport which this court has held is something which is so egregious and cruel that it cannot and ought not continue. That's the background. Now, on this point, I'm just giving you paragraphs. I'm not going to read it. Page 15 is the judgment in Hadige Sham Bhatt. It's another Constitution Bench judgment. The report is given 63, 3 SCR, page 809. You may just note the relevant paragraph, which is at page 17, paragraph 7. Page 17, paragraph 7, which says phraseology. I'll just read those 5 lines. Paragraph 7, after the quoted portion, though a ex facie law appears to treat all that fall within a class alike, this is an Article 14 case, if in effect it operates unevenly on one person or property situated similarly, it may be said that the law offends the equality clause. It will then be the duty of this court to scrutinize the effect of the law carefully and ascertain its real impact on persons or property similarly situated. Conversely, the law may treat persons who appear to be similarly situated differently, but on investigation, they may be found not to be similarly situated. To state it differently, it is not the phraseology of a statute that governs the situation, but the effect of the law that is decisive. The effect of the law is decisive because you just see the material, which I'm going to come to. Now, this passage, you may just note in the very same, because this is a 5-judge bench judgment, which your lordships have seen, has been endorsed by a 9-judge bench judgment, which I've placed in this, just 2 pages. Page 67, Chief Justice Thakur's judgment at 68, where this passage is quoted at page 68. So that is the entry tax case, etc. 9 learned judges of this court have endorsed this very paragraph that I read. To state it differently, it is not the phraseology of a statute that governs the situation, but the effect of the law that is decisive. So that's at page 68.
This
And
is the pit and substance in all the tax statute.
so,
Where
yes,
the coal says,
correct. So your lordship is right. So pit and substance was in the context of when Maneka Gandhi's analysis is under Article 21 and it draws in pit and substance. Why? Because as your lordship correctly put it to me, a levy, say in Bennett Coleman, was being defended under Article 265, etc. And they said that the pit and substance is under 265 or whatever. Don't challenge it under 191A. This court says that it is not going to go only by the facial.
the actual purpose of the law was tested.
Yes, the actual effect of the law.
The origin that
The effect of the law.
US Supreme Court.
That I try and obtain the US Supreme Court case. I'm sorry, I don't.
The Chinese laundryman case.
There is.
Hopkins,
Yes.
I was
Yes.
trying to cite it.
Oh,
You
very good,
mentioned.
very good, Madan. You're right, Lord.
That we, versus not of, yeah. That's possibly
The laundry case
The
may be.
famous evil eye and unequal hands. And therefore, if abuse is seen, this court, my lords, in a constitution bench, Justice H.R. Khanna has said that if that is established, then that is an exception. And therefore, you can look at the statute from that standpoint. That's what my learned friend is saying. If for 5 years after the statute is implemented, this is what you find, then you can't ignore it, saying that the statute.
So, my lords, I think Mr. Venugopal has put it very correctly. I believe it's extremely hazardous to ignore the facts established over 5 years, which are not contradicted and not controverted. Now, just nothing further. Page 23 is another Constitution bench judgment in Federation of Hotels versus Restaurant. And the relevant paragraph is paragraph 46 at page 47 of this compilation. Again, saying it is not phraseology which is determinative. What is determinative is the real effect of the provisions. Now, further on this compilation, please go. Now, yesterday, there was an issue which was, because a question was specifically put to me. I obviously hadn't read it, and I'm not going to tax this bench either by taking you through all the reports, so I'll go through one, the 2020 report. But the specific question put to me was like, how was this prepared? How was this prepared? Now, please go to page 69. Page 69 is an affidavit which we have filed today, only giving you as to how, because the report itself says how it was prepared. But this is in addition. So this is by a Deputy Director Advocacy Project of PETA. Please just go to paragraph 2. The petitioners have filed investigative reports in page 69, 17, 18, 19, 20, 22. The photographs forming part of these reports were taken by the ground investigators of the petitioner using DSLR camera, mobile phones, handycam and digicam. The photographs were clicked at various locations, including the arena, gallery, bull waiting area, and the collection yard. The said investigators have not been named in the report in order to protect their identity and safety since it is a sensitive issue. The ground investigators of the petitioners covered 5 Jallikattu events in 2017. We have given the dates and the details. Ground investigators covered 9 Jallikattu events in 2018 for around 14 days between 14th January and 28th January. Para 5, the ground investigators covered 7 events in 2019 between 15th January to 3rd February. Para 6, the ground investigators of the petitioner covered 7 Jallikattu events in 2020 held between 15 January 2020 to 19 January 2020, and similarly 21 and 22. The contents are true, etc. The final part is, and I'll be closing with this, but not for the moment. I'm just inviting your attention. Page 73 is a definition, not definition. It's a description of what constitutes blood sports taken from the Encyclopedia of Animal Rights and Animal Welfare, the relevant portion being at page 75. Blood sports are defined. This would be covered by blood sports. And please see the last 3 lines on the right-hand column on page 75. Bullfighting is an example of animal baiting, in which an animal is goaded into aggression through pain, taunting, cornering, and so on. Then they go on, and the next para, animals subjected to blood sports routinely suffer terribly, both during the events and during the training of fights. Losing animals are often killed, etc. So this may be in a different context. Now I'm done with this particular compilation, but this is indeed a blood sport. Now please just take up the compilation I handed over yesterday.
Mr. Diwan.
Yes, I'm sure. Yes, please.
Blood sport is a term that you're using.
Yes.
We find it very difficult to relate to the term that you're using.
Yeah, it is a blood sport. So just take up.
Why do you say?
It is. Yes, I'll tell your lordships why. So just have a look at the definition. We have a paper, in fact. Just have a look as to why this is nothing but a blood sport. Let me just tell you what it broadly involves. A blood sport is an event which used to be very common across the world, and it involves typically an animal, it involves a fight or a contest, and it involves, as has been found, a great degree of brutality and cruelty. That's one. Secondly, the scholastic material which we will place on record appears to indicate this, that there are movements across the world starting from the 18th century onwards, which diminished cruelty from a citizen's point of view. So there was an awareness among citizens themselves that, look, this sort of a thing ought not to continue, this sort of a thing should be restricted, this sort of a thing should be regulated. So that was one trend line. The second trend line was scientific in nature, because our understanding of the sentient nature of these beings also increased. So that was a second huge push. And this combined with a general awareness and legal reforms. So the reforms came in different ways. Some countries, there were statutes which were brought in. Some portions, in some parts of the world, culturally it changed. I'm sorry.
I don't think I'm getting an answer to the question I have posed. How you are describing this?
All right. So,
blood sport.
yes. So
nobody is using any saber. Nobody is using anything.
It's not necessary.
Illicit blood.
Sorry.
So you are talking, I'm specifically talking about your understanding of the concept of blood sport.
Yes.
Why blood sport?
Yes.
If
So
you look at a bullfight, they eventually try to
Just a
kill
minute.
the bull.
Pull it out.
yes, sorry.
Another this thing,
Right.
with a saber.
Yes.
They use a weapon.
Yes.
Here people are barehanded. Why are you describing?
Yes.
You may say that there are cruelty involved,
Just-
but you can't be describing it as a blood sport.
It falls. So
Don't give us the example of this definition at page 75.
No, I'm going to give you as to how blood sports are defined. And there's a scholarly paper. Have you got copies? Yes. We've given copies. Now, why blood sport? Now, let's just answer this question.
Yes, you must.
Yes. let us just understand what is meant by blood sport and what's the scope of blood sport and whether this answers the description. Now, this is a paper which is part of a master's thesis, which I'm just handing over, which has a huge description. The author of the paper is Jack William Perryman. And now please just have a look as to the nature. I'm only answering the question. Please go to page 13, the nature of blood sports. So let me just see this, read this, and then your lordships will see it answers the description. Please see B, page 13, the nature of blood sports. Sports expressing an obsession with the death and torture of animals were popular throughout England. This is looking at England and America.
Correct.
The cruel amusements have been referred to by those attempting to prohibit them as blood sports. The term blood sport was used because the rules of the sports included the maiming, injury, killing, or bloodshed of innocent animals. Henry Salt, editor of one of the few books pertaining to blood sport, defined blood sport as those amusements which involve the death or torture of sentient beings.
You
further stated,
Mr. Diwan, you avoided 3 words while you were reading this sentence.
No.
Henry Salt, please read that again.
Henry Salt, editor of one of the few books pertaining to blood sport, Killing for Sport,
Yes,
1950.
killing for sport. Killing
Yes,
for
yes.
sport. This is
Define-
avoided reading.
Yes, defined blood sports as those amusements which involve the death or torture of sentient beings. He further stated that the worst and most demoralizing form of blood sports were those which make use of tame or captured animal and not one that is really wild and free. Blood has always been an important symbol and universally attributed with a special significance. In blood, an old hunting phrase, popular as early as the 17th century, means in full vigor or full of life. Raised in blood, another famous sporting line meant to make eager combat or bloodshed. Although no reliable source of information is available, the term blood sport itself seems to have become popular in England during the latter part of the 18th century as part of the propaganda of reformers, individuals who worked to eliminate cruelty from British sports. Later, around the 1820s, Humane Society leaders and humanitarians in England adopted the term. Blood sports soon became associated with cruel animal sports such as cockfighting. Bull and bear baiting. Please see, bull and bear baiting has nothing to do with the death of the animal. Dog fighting, gander pulling, rat baiting, snatching the rooster, the cock throwing in America by the 1830s. The cruel nature of British had been allured to by numerous travelers during the 18th century. The French, more than others, frequently commented on England's bloodthirsty people. So-and-so, a traveler through England in 1775, was shocked that all life was sacrificed in such abundance that blood flows by the brookful. Earlier in the same century, a visiting scholar so-and-so remarked in regard to the British that there's something in them that is great and which they seem to retain from the old Romans, that they have to this day a sort of gladiators, bull and bear baiting and dog fighting. Even as recently as 1875, Rapin, discussing British historian Max Lenner described the relationship between sport and blood. Sports do not for the popular culture of America what circuses did for the Roman culture at the height of the empire. They let the populace take part in this crucial ritual that binds them to another and to the culture. Every people, no matter how civilized, must have a chance to yell for blood. It can certainly be argued that blood sports were not only inherent to the British tradition. Still, blood sports were very popular amusements in England and America during the 17th, the 18th, and the early part of the 19th century. To some extent, this popularity must have reflected a culture in which cruelty, severe punishment, and an obsession for violence were prominent characteristics. Blood of death of an animal. That's the first point I want to make. Even in the human context, blood sports, which are like jousting, etc., may be gladiatorial, etc., but they fall short. They need not necessarily result in death. Here, of course, we have seen documented deaths of bulls, etc. Documented.
You see,
Sorry.
Mr. Diwan,
Yeah.
because death occurs, it doesn't mean that it will be a blood sport. All I'm trying to say, and I have not got an answer, at least to my satisfaction.
Yes.
I don't suggest
Yes.
that people who are going to participate in climbing onto the bulls are going there in order to extract blood in that sporting event or whatever event that they wish. I don't think blood may be just an incidental thing, but it's not a blood sport. I don't think it's.
May I just say,
difficult for
first
me
and
to
foremost,
relate.
the expression blood sport is being used by me not because it is linked necessarily to the exposure of blood. A blood sport is an animal baiting exercise involving extreme cruelty. That's where I end my definition. That is what this scholar says.
You have said
And that's what the conclusion also says.
You have said so.
Yes.
But the bull owners are obviously not exposing their animals. But I don't think anybody is going there to participate in this Jallikattu sport to say that let us expose the animals to extreme cruelty. That it happens is another matter. I am taking exception to your use of the expression blood sport.
Anyway, I would describe.
You have given your answer.
Yes, I'm grateful. Now, I am not going to read it, but the summary and conclusions begin from page 198 of this. I'm not going to read it.
It is of some utility, I believe, in the context because it explains how there's been a gradual global shift away from animals in the arena which inflict cruelty, whether we call it label it as a blood sport or something less than a blood sport. Now, I want to just answer one facet of this act. And I'll deal with that on the basis of what we have already said. I'm answering a part of the question. Please go to the yesterday's compilation, which I've handed over, the compilation I gave yesterday, and please go directly to page 19, 19. Facts concluded by the earlier decision in Animal Welfare Board. Now, while that's being located, yeah, sorry.
This starts with the chart.
Yes, table A. So I'm going to table D, which is page 19. It's part of the answer. I'll just state the point while that's being located. The top page is compilation and rejoinder.
It's filed by Anne Matthew.
Yes, it's filed by Anne Matthew.
One question from the petitioner said. Sort out that.
Now, sorry. May I take you to page 19, please?
Here.
Sorry, your lordships have page 19.
19, yeah.
19. This is of that. The heading is facts concluded by the earlier decision in the Animal Welfare Board of India, Nagraj. Now, the third last bullet point, I'm just reading it.
Page 19 you are reading.
19, yes. It's on top, it's titled, it's stated to be table D.
It's not really a table, it's a table of findings. And we've given you the specific paragraph numbers from the SEC report. So please go about third bullet point from the bottom. These are all culled out from the judgment itself. Jallikattu causes bulls severe mental and physical anguish. Now, this is a finding of fact. So, apart from all my other arguments that it can't be overturned and accept in review, etc., this is a finding of fact. Jallikattu by itself causes, by the nature and the anatomy, severe mental and physical anguish. Next bullet, Jallikattu is dangerous to humans. Next bullet point, pain and suffering are biological traits. Animals have pain receptors and a memory that allows it to remember what caused the pain. Pain felt by the animal is similar to the pain felt by man. Now I'm going to read only two more on page 20.
The way they argued that mountaineering is also equally dangerous. People die every year. A lot of
right. So I think
govern this one.
Yeah.
The mountaineering. You have the mountaineering club.
Yeah.
It extends.
Yeah, Mr. Rodgi said driving a car also.
Driving a car. Also.
Yeah, yeah.
So do we stop people from climbing mountains?
No. So let me answer that.
Adults. Wow.
No. So let me answer that. The answer. So here, it's a slightly different question over here, as I at least understand it. This is a question of inflicting cruelty. It's a question of inflicting cruelty. And that ought to stop in terms of the animal. Now, let me answer the point which your lordship made, because you could have sports. So, there is a concept which your lordships are aware of adventure sports or adventure activities.
Boxing.
Boxing also maybe, yes, it's possible that it is, it's certainly something.
It's a bloody sport.
Yeah, it is, it can be. Now, therefore, you have a response. So therefore, there's a global debate which is going on as to whether people should be wearing safety equipment, what is the type of safety equipment. There are now long-term studies which show that even the most successful boxers suffer brain damage. So they suffer brain damage even though there may not be any apparent injury on it. So there's a lot of science which is developing. Maybe the law will evolve in a particular manner. But
Muhammad Ali, yes, Muhammad Ali already.
yeah, that's very, very possible. Very possible. So my answer to that is that if there is cruelty which is being, so this is, but I would not put, I don't believe mountain climbing, for example, since that's the example given to me, or driving a car amounts to cruel, or boxing voluntarily done amounts to cruelty. I don't think it amounts to cruelty. We are here on prevention of cruelty.
Cruelty to whom?
Cruelty to animals.
You spoke through the conduit of human beings.
Absolutely.
Invoking 21.
Absolutely.
So you are concerned about human lives being lost.
Both, yes.
That was what was being argued by the
Right. So, yeah.
It is voluntary. They agree. You can't
Both.
stop the adventure in the spirit in the man. That he wants to take the risk.
Yeah, so I'll just answer. Yeah.
Diving from,
Correct. So I don't think, yeah, you're right. So, Ballard, I think in aspects of driving a car, I believe there are elements of human agency involved. Animals, or our understanding of the situation, but lack that agency, and therefore they are compelled to, which is why we have the Prevention of Cruelty to Animals Act. And when you, because they don't have
We
agency.
are only talking about it from the standpoint of the human beings.
Yes, so there are two, your Lordship has put your finger on it.
You don't have to argue.
Yeah.
They can't give their consent.
Correct. So, Manoj, now I would like for that observation. My point over here on page 20 is the last bullet point. Jallikattu and other forms of bull races, as the various reports indicate, cause considerable pain, stress, and strain on the bulls. These factual findings completely establish the practice of Jallikattu is inherently cruel to bulls, apart from being extremely dangerous to human beings. These factual determinations, which have attained finality in relation to the state of Tamil Nadu, ought to be taken as conclusive. The submission is founded on the premise that legislation cannot open judicially determined facts, and as such would be colorable. No material has been brought on the record in the form of scientific and technical reports that undermine these factual findings, and the Supreme Court itself ought to be respectful of the constitutional architecture, whereby once a review is dismissed, facts cannot be reopened through the judicial process. Now, just going back to my table A, I'm not going to read it. Table A is a summary of all the details of all these reports. And I answered, or at least I endeavored to answer the question yesterday, which was the news reports are not random news reports. The news reports are from very reliable media journals. They have not been contradicted outside the court. I can understand, because the number of deaths of human beings, of a child, of a policeman, of the spectator, of participants is huge, apart from the deaths of bulls, which are also documented. And we don't believe that reliable media houses would be making a story up in terms of all these deaths are concerned. So I agree, it is inherently, I think your Lordship's observation is quite right. This activity is inherently dangerous. It involves risks, etc., insofar as the human beings are concerned. Those human beings, I accept, are probably have an element of agency, the bull tamers. But spectators are dying. So someone may argue that don't go and watch it. Spectators even outside, your Lordships will find, if you find the time to go through this, spectators outside the bull run area, etc. Barricades are being, the bulls are jumping over barricades and goring people to death. And this is what we found in 4 and 5 days of investigation. So please consider that. That's table A. Now,
So, Ballard, this is very detailed. It gives huge number of photographs and our sources, etc. Table A. I'll explain what we've done in table B. In table B, we have taken annexure 1 from the affidavit which they have filed regarding the process. Your Lordships had asked them to file an affidavit saying, please explain the procedure, what happens. So we have extracted the procedure on, we've reproduced actually
in the left-hand column. We've reproduced it. And then we have given you the corresponding rules under the 2009 Act and the 2017 rules. And sorry.
Statement. And what you will find if you go through this is that it's really everything which was there earlier is really captured was already captured in 2009. And what they have said in paragraph 5, those participants who are intoxicated or suffer from deformities, we have made a comment that the state should not file affidavits which use expressions like this, suffer from deformities.
This does not appear either in the 2009 Act or in the 2017 rules. And then we have given certain further details, etc., going right through towards the end. And for example, 8, when it says a second bull is let into the arena from the Vadi Vasal, after the previous bull has been let out, left the arena, it is ensured that any given point of time there is no more than one bull in the arena. Apart from the photographs, our comment is this does not appear in the 2009 Act or in the 2017 rule. That is our comment. And now please see 2018, my mistake, table C at page 16. Table C at page 16. So here we have given a comparison of the 2009 and 17 regimes. The role and duties of the collector remain more or less the same. The role and duties of the animal husbandry department remain the same. The organizer's duties remain the same. Penalty which was there earlier has now been removed. There is no penalty at all. Page 17. And you have a set of rules which we have. The animal welfare activists being present has been omitted. And at serial number 6 on page 18, we have pointed out that whereas they claim that there are rules now which govern, we have put overwhelming uncontroverted material on the record, which in our view establishes that there is no, the breach and cruelty being visited is such. Now, Manoj, I have just had a few minutes to reflect on this expression blood sport, because an issue was raised that we have used, and I have used the expression, because not in the pleadings, etc., the expression blood sport in a generic sense of a sport or an activity. I wouldn't even call it a sport. An activity or an event involving cruelty caused by baiting to a bull. Now that baiting happens on different occasions in different manner. It may happen with a physical slap. It may happen with a jab. Merely prohibiting is not going to be enough when on the ground, this is in fact what is happening. So I'm very grateful. There are a few small other points. Sorry.
2 points we'd like to tell.
Yes, certainly.
The blood sport is very literal.
Sorry?
It is literal meaning to all these blood sports.
Yeah.
It does involve bleeding of the animal.
Yes.
Now, in 2000, when Nagaraja was actually decided,
Right.
you would have been correct in describing it as a blood sport because
Right.
animals were being, here and whatever, sharp material they were using.
Right.
It did involve actually blood loss.
Right.
Under the present dispensation, all
Yeah.
of that, at least in theory on paper.
No, but we have put the photographs on record.
Now,
We-
two
showing the
things
blood.
we
Sorry?
wanted to clarify that about blood sport, what it means.
Yes.
I want to ask you 2 things.
Yes, certainly.
In the event that we are upholding these rules,
I'm sorry.
in the event,
Yeah.
we're just putting it to you as
Alternative. Yes.
alternative.
Yeah.
Like they have come forth saying that they're amenable to any kind of suggestion from the court.
Yeah.
What would you like to put in place, put in place, which would vastly improve, the condition of the animal? Number 1. Number 2, do you have to give any elucidation of the position relating to the rights vesting in animals in a jurisprudential way? What is it that you would like to tell us? Do you have anything to say?
Yes. So first, Manoj, I'll answer both aspects. The first point which I want to make is that I'm going to supply, because, for example, I have it immediately before me, page 74 of the 2020 report. That's a bull and a bleeding individual at page 83. But I don't want to take up your time. So I'm going to give you a statement of photographs depicting images taken from this event by our field investigators showing the spilling of blood human as well as bull. So that's going to be one part of the answer. So the blood sport element, the blood literal element in our respectful submission continues. The second, my lords, please excuse me, but I decline the invitation of providing a safeguard with regard to this thing, because we are fighting here as a matter of principle, and we will endeavor to persuade this bench or some future set of legislators or these things if the matter goes against us. But on this issue, I don't want to compromise. The third element was rights. That's a very important facet. Now, let me just indicate where we are. First, I have explained this in the opening, but so I'll just take 2 sentences.
And Mr. Rothgi put it accurately, I felt. The foundation of animal rights, which have been used for the purposes of deciding Nagaraj, is a reflection of what the duties are as far as people are concerned, which are clearly, imposed, not imposed, but called for, required under our fundamental duties section, a chapter of the Constitution, as well as the Prevention of Cruelty Act, which puts it. So it's really a mirror image. So let's not use, so Nagaraj doesn't use, in my understanding, rights in a conventional, traditional sense as we would attach to human beings. 1. 2, because I would commend the formulation by Justice Bose yesterday, that does it really make a difference whether we label this as rights or duties? Because at the end of the day, the object of the law is to prevent cruelty, and we would implore your lordships in whatever manner to ensure.
We want to know
Yes.
whether when Nagaraja says in paragraph 64, 65,
Yes.
66, 67,
Yes.
that they are at present rights under section 3 and 11.
Yes.
In favor
So,
of
my lords,
rights,
yeah.
be elevated to constitutional right.
Yeah.
Are you saying that is the correct?
So, lords, let me, now I'm speaking for myself, but then your lordship, because I answered it, addressed your lordships very narrowly. So I'll just first stick to my guns in, so to speak, as I did during the opening, and then expand it because your lordship says from a jurisprudential perspective. That other counsel did. Now, on the narrowest, if your lordship really, yes, please see those paragraphs, but please see the earlier paragraphs as to how the judge has articulated it. He has not said that this right is available under this section to this animal or the other. No, it's a very carefully and very well calibrated judgment, if I may say so. The reason I say that is that he draws on rights, or the animal rights which he pegs on. The animal rights Nagaraj is speaking of. Let me talk about that. The animal rights which Nagaraj is speaking of is 1, the reflection of the duty imposed on humans. 2, an assimilation of the 5 freedoms which are universally recognized, which I had mentioned in the opening: freedom from temperature, hunger, etc., thermal, etc. So that's another element into the rights of animal. That's the minimum requirement. And the third broad element which the learned judge finds is that, look, there is an improvement over time. There's an evolution of these recognition in terms of sentient beings, in terms of our understanding of biology, physiology, in terms of the bull. And therefore, we are moving in a direction where animals such as the bull, which is the only thing he was dealing with there, are at now a stage when we can, or the time has come when perhaps like the German constitution, some recognition ought to be given over there. But jurisprudentially, we're not speaking for myself. If the court is asking whether Nagaraj says that, look, a person A or B or C for an animal can come to court and petition, say, habeas corpus. So your lordships may be aware of the Happy case. Are you aware of the Happy case? No. All right. So Happy is an elephant in Brooklyn Zoo. And Happy went through an animal protection group and filed habeas corpus. The relief was quite limited. The relief said that, look, as far as animal rights, I am seeking habeas corpus, and the relief was that I don't want to be confined to Brooklyn Zoo, but please put me on a larger area, which,